But before we get into that, let's just quickly get into the conversation with lawyer Muthomi Thiankolu, who now joins me in studio as we just take a look at what these petitions mean. 6 out of the 7 Supreme Court judges so far have petitions filed against them seeking for their removal, and most of the grounds are gross misconduct from what we are seeing from these petitions. Muthomi, thank you very much. Always a pleasure to have you here on KTN News Desk. I believe you have had or seen snippets of the petitions that have been filed against the DCJ and Isaac Lenaola. Do they meet any legal merit according to you?
First of all, Akisa, it would be prejudicial for me to say whether these petitions have merit or they have no merit, or anyone for that matter. It is too early in the day for anyone to form that opinion. Having said that, I must point out that the 5 grounds you have played for your viewers are exhaustive. That is to say, those are the only grounds upon which you can remove a judge. And if I may expound on them, and in particular the one on gross misconduct,
yes.
It is not every misconduct that would warrant the removal of a judge or any other person, for that matter, from office. If, for instance, you and I have an altercation in this studio of a purely maybe personal nature, or if I receive a parking ticket, or I'm stopped by the cop. Just to give you mundane examples, the misconduct in question, one has to be gross. It has to be something that brings to serious question the integrity and the suitability of the person to hold office, and it must be misconduct of a type that demeans the particular office you hold. So our viewers should know that it is not every, misconduct that will pass this test. If we talk about the other grounds, if for the benefit of our viewers, you're removed for bankruptcy on the assumption that someone who is bankrupt is financially vulnerable and therefore incapable of exercising the sort of independence expected for you to hold judicial office. If you look at incompetence, the ground of incompetence simply means that you lack the intellectual and professional acumen required to discharge the functions of that office. For instance, a judge is supposed to have a good command of the law. Is expected to understand legal principles, and especially the basic ones. So when we are talking about incompetence, what we are simply saying is that maybe we made a mistake in the first place when we appointed you, because someone who was competent at the point of appointment is deemed to have had the requisite intellectual and professional capabilities that are required to discharge the functions of their office. You could be competent, you might not have committed any offense, but you might be unable, perhaps because of illness, because of mental infirmity, to discharge the functions of your office. Now, whether, of course, any of these grounds is met in any one particular case is a matter of the facts of that particular case. And what usually happens is once you place this petition before the JSC, the JSC will peruse the petition and ask themselves, does this petition meet the threshold envisioned by law? So the mere filing of a petition does not actually mean that petition will go anywhere.
We'll go through. And one of the questions that I've gotten from a number of our viewers, what does the JSC do and what does a tribunal do in the event that it's formed? Just clear that up for us.
The role of the JSC is to sift. It's like a sieve, really, to ensure that we don't invoke this process of allegations that are completely outlandish and devoid of merit. So it is like, to use the language of the street, it's a mchunjo. So the JSC will look at the allegations, the supporting evidence, and ask themselves a very simple question. Is this a serious case, or is it just one of those frivolous complaints?
But you mentioned gross misconduct. It's one of the reasons we've seen a number of judges whose petitions have been filed against them. Gross misconduct almost never lacks as one of the reasons for the removal of a judge. From your experience, you have been in the field for a very long time. What are some of the grounds that have been very dire as far as gross misconduct is concerned?
Examples of gross misconduct may involve, for instance, taking bribes or succumbing to other form of improper influence in the discharge of judicial functions. Some of the allegations, and I said we don't know as of yet, the JSC as itself previously ruled that if a judge is too close to the litigant and is interacting with them during the ongoing of a case before them, that could form a ground for removal, but again subject to the qualification that we do not know, and no one knows as we speak, not even JSC itself, whether these allegations have merit or have no merit. The other thing I wish to clarify for our viewers is deciding a case one way or another cannot conceivably amount to gross misconduct. It is not enough for you to say that because the judge made a judgment with which I'm very unhappy or which I strongly disagree with, that is strong misconduct.
Gross misconduct.
You have to show that there is something between that outcome and conduct that would be gross using the constitutional threshold. I will also wish to point out, because there is a trend emerging, where we tend to assume that if we don't like judicial outcomes, then we must throw mud at judges and say they are guilty of this or that or that. We must appreciate the role of a judge is the case can only turn one way
or the other.
And both ways are within the law. The judge is not obliged to allow or disallow a case.
And that brings me to my next question. All 6 of the 7 Supreme Court judges so far have petitions filed against them, including the Chief Justice himself, David Maraga. What does this do to the image of the apex court of the land?
The mere filing of the cases, for me, what we should read it is its timing and context. The timing of these petitions coincides with a decision that one side of our political formations seem to not have taken very kindly. And therefore, for me, Kenyans should see these petitions in their political context as evidenced by the timing. The only unfortunate thing, assuming these petitions have no merit, is it will mean as a country we are willing to destroy our institutions just for political expediency, just to make a political point. And I want to encourage maybe all our citizens to learn that it is not every time you lose a case that the loss is attributable to misconduct or anything sinister. Speaking for myself, I've practiced law for many years and I've lost countless cases. And in none of those cases have I attributed the loss. Maybe sometimes you lose because your argument is weak. Maybe sometimes you lose because the law doesn't support your version of the events. Maybe sometimes you lose because your strategy is bad. It is always easy, and it's natural in human beings, to attribute disappointing outcomes to the judge. Because, you know, judges don't call press conferences, judges don't address political forums, therefore they become a soft target to explain.
Yes, quickly, before we end, we had another ruling on presidential petition in 2013. We did not see such a huge number of petitions being filed against the judges of the Supreme Court then. Currently, almost all the judges have one issue or the other to deal with, just a day to when they're expected to deliver the full judgment. How do you assess this whole situation that we find ourselves in as far as our politics is concerned, and coming at a time when we are heading into another presidential election?
It just shows the short-termist view and short-term approach of our political class. It is amazing for me that the 2013 decision had more fundamental problems, countless of them, than any possible problems that we might find in the judgment that will be read tomorrow. Yet no one moved to remove any judge from office as a result of that decision. And I think that betrays the insincerity, perhaps, in some of these petitions. Like I said, what should really worry us, after NASA and Jubilee are out of the scene, because they surely will be, after Raila and Uhuru are out of the scene, shall we still require our courts? There's the ordinary odd that 40 million, 45 million of us need the courts. And what will happen if we destroy our courts just to place Uhuru or Raila in State House? For me, it's a very responsible way to approach our institutions. And this could apply not just to the courts.
Yes.
There are many other institutions we seem prepared to completely demolish just to achieve the short-term agenda of being MP, being governor, being president. And I think the citizens should actually call the political class and read the Riot Act.
The Riot Act on them, yes. Because anyway, it's us they represent. Thank you very much, Muthomi. Always a pleasure having you here on a KTN News Desk. Muthomi Thiankolo is a lawyer just helping us understand what are some of the processes we'll be looking at. Why are things happening the way they are at a time when Kenya is going through a number of things. Tomorrow, the